Welcome to the Ezra Digital 2021 Education Series. I would now like to turn it over to Steve Bisbee for introductions.
Good afternoon, and thank you for joining us today. I'm Steve Bisbee, founder of eOriginal, a leading digital transaction management platform for financial services, and now a Wolters Kluwer company. I oversaw the development of unique digital solutions that replace paper processes and created business efficiencies for over 700 clients in a multi-asset digital financial ecosystem. The Electronic Signature and Records Association was formed to educate and advocate for the use and acceptance of digital signatures, records, and transactions. I have been on the Ezra board since its inception. Ezra members are dedicated to providing, promoting, and participating in Ezra values, which are expertise, leadership, collaboration, accessibility, and technology neutrality. Part of Ezra's educational mission, this is the second annual education series that will run through December. The intention of the series is to provide insight and practical guidance on the business, technology, and legal implementation issues that arise across a wide spectrum of use cases. Although the eSign Act was enacted over 20 years ago, there's still a learning curve as companies continue to transform their businesses. These issues are even more critical during this continuing period of social distancing, remote work, and contactless customer engagement. We hope that you find these webinars useful. I would like to introduce our speakers today, Margot Tank and Dave Whitaker from DLA Piper. DLA Piper is a global law firm with lawyers located in more than 40 countries throughout the Americas, Europe, and the Middle East, Africa, and Asia Pacific, positioning them to help their clients with their legal needs around the world. Margot Tank is a partner that has been assisting companies with digital transformation for over 20 years and has reviewed and advised on over 1,000 processes and platforms that enable digital transactions and digital payments, including those in financial services, commercial and consumer retail, commerce, and healthcare. Margot has significant experience in applying the law to the issues raised by new technologies, such as electronic signatures, digital asset transfer systems, artificial intelligence, blockchain, smart contracts, and virtual currency. Her clients range from Fortune 500s to startups. Currently, she and her team are working on over 50 digital transformation projects, including some that span the globe. Dave Whitaker, also a partner, advises traditional and emerging financial services companies and commercial enterprises in transactional, legal, and regulatory matters, particularly those related to electronic commerce and digital financial services. He has extensive experience with the practical application of the laws governing electronic banking, letters of credit, payment systems, records management, and commercial and consumer financing. David also advises clients on laws related to privacy and data security in connection with electronic financial services and payments. He has written extensively on both law and legal practice related to digital financial services, electronic commerce, and digital transformation. On a personal note, I've known Margot and David for 20 years. They were legal pioneers in supporting the UETA, the eSign Act, and other enabling legislation, which really made the digital environment in which we operate in today. Please welcome Margot and David. Margot?
Sure. Thank you, Steve. Very nice introduction. Excited to be here today with my partner, David Whitaker. We're going to talk about some of the legal and regulatory trends and issues that come across our desk. In particular, this year, there has been, as you would expect with COVID-19 pandemic, people still working from home. There are so many issues that we're discussing and advising on. And COVID-19 has clearly accelerated adoption both for businesses and consumers. And we're excited to talk about some of the issues. So we won't cover everything because there's a lot. There's a lot going on. We're going to call out some highlights. We're going to focus on continued progress, meaning adoption. We're going to talk about some of the issues that we're seeing, both case law and regulation. And then we'll talk a little bit more in depth about remote online notarization, which seems to be taking the country, if not the world, by storm.
All right, we'll start by just noting that the UETA finally seems to be taking hold across the United States, yay, with the adoption by 2 of the 3 holdout states of the UETA in the last year and a half. Roughly last April in 2020, Washington adopted the UETA, replacing its Digital Signature Act and repealing the prior act and fully replacing it with the UETA. And then finally, Illinois, just this year, effective June 25th, 2021, replaced the Electronic Commerce Security Act with the UETA. Those of you who have been following this area of law for a long time will undoubtedly remember that the ECSA was really a precursor to the UETA. It was developed in the state of Illinois. A good friend of ours, Tom Smedinghoff, was deeply involved in the creation of the Illinois statute that predated UETA and served as one of the foundational references for the creation of the UETA. Now being supplanted by the UETA in Illinois, leaving only, as in so many other things, the state of New York standing alone, determined not to admit that there's a better option out there than the homegrown statute that they wrote. So the New York Electronic Signatures and Records Act will continue to exist, although the court cases in New York really have indicated that they view NIESRA as essentially being the rough equivalent of the Federal E-Sign Act. And of course, finally, we'll note that all that being said, there's still the UETA in California with roughly 69 one-off amendments stuck into it, with a special exclusions for one kind of California statute or another. So every time you go to use electronic records in California, bear in mind that there's a whole extra litany of exclusions you need to work your way through to make sure that things that would be covered anywhere else now in the United States still aren't covered necessarily in California.
So blockchain amendments, there has been a lot of activity over the last 14, 18 months where states are feeling the need to either amend the UETA or enact a standalone piece of legislation to enable distributed ledger technology, blockchain, smart contracts. They're doing so in a very interesting and perhaps troubling way. They're creating definitions of distributed ledger technology and smart contracts and blockchain that are A, not uniform, and B, not necessarily technology neutral in all cases. These amendments, and we've been, as the Electronic Signature and Records Association, have been working with the Digital Chamber of Commerce and the Uniform Law Commission to provide comments and education to some of these states to say that the amendments could potentially sort of undermine the UETA in a number of ways. I mean, A, the lack of technology neutrality is critical for a long-lasting statute. Undermining the efficacy of the UETA as a minimalist statute, as a legal baseline to enable electronic transactions. The definitions in the UETA and e-sign, for that matter, of an electronic record and electronic signature were drafted specifically with the ability to encompass all forms of contracting by electronic agents, distributed ledgers, and didn't need to specifically call out the terms blockchain. I think that some of the risk is that the lack of uniformity will cause complication in implementation at some point down the road, whether it's at the court level or at the regulator level. There's always risk of federal preemption as well, because the e-sign, how it's crafted, says that states can enact the UETA, but it needs to be in a form that's consistent with that was promulgated by the Uniform Law Commission in 1998, and any variation thereof that's inconsistent with e-sign could be deemed to be preempted. So I think, there's good intentions out there. There leaves much potential for problems later on.
Next, we're going to note that we are continuing to see the slow march of authorization for electronic wills across the United States. Once again, those of you who are longtime followers of the UETA and e-sign know that wills and codicils are excluded from UETA and e-sign explicitly, and possibly also implicitly, because there's always been a question about whether or not they fell within the definition of a transaction, because basically they are essentially unitary acts by individuals. They don't necessarily involve another party. At least now 9 states, we have 7 listed here, but there are 2 brand new ones, Colorado and North Dakota, have now adopted electronic will statutes. 4 of those states have adopted the brand new Uniform Electronic Wills Act that was promulgated in late 2019 by the Uniform Law Commission. And in particular, one of the most recent adoptions by the state of Washington is an adoption of the Uniform Electronic Wills Act. And one of the things to note is that if you adopt the Uniform Electronic Wills Act in its pure form, remote execution of the will is permissible, and that includes remote presence of the witnesses. The witnesses need to be in the electronic presence of the signer, but don't necessarily have to be in the physical presence of the signer of the will at the time the will is executed. That is not true in all states. And so one of the things you need to be careful about is that there are states where, at the moment at least, it does not appear that remote appearance by witnesses or remote notarization is actually authorized, even though the will can be executed electronically if everyone's gathered around the computer. But again, in the uniform will states, if they adopted the pure form, then remote notarization and remote witnessing would be permissible. Also important thing to note, Illinois is a recent adopter of an electronic will statute. One teensy little problem. The Illinois statute, which is not the Uniform Wills Act from the Uniform Law Commission, requires the use of a signature that includes a security procedure as defined in the now repealed Electronic Commerce Security Act. So it's not really clear at the moment exactly how active or how usable the Illinois Act is, because it requires a signature process mandated by a non-existent statute. More to come, I assume, on that. I used to work in the Illinois legislature, and how that works is you come to the end of the session in June and nothing has been passed until the last 48 hours. And suddenly dozens of bills appear on legislators' desks and get passed. So you can see, if you've been in the Illinois legislature, how confusion like this could have happened. But what it probably means is that it'll be next June before we get a revision to the Illinois will statute to clean up that inaccuracy.
In addition, there's been, at the state level, there's been a lot of activity in the insurance sector. There are a number of states that are, notwithstanding the adoption of the UETA, are enabling disclosures per underlying insurance law, statute, and or regulation. So just a reminder to make sure that when you're advising or implementing in this area, to go and look at the property and casualty, annuity, life insurance laws to see if they have enabled insurance disclosures. There are some states that have also, in addition to incorporating e-sign 101C consumer consent provisions into the UETA, are also adopting in the insurance laws themselves consumer consent provisions that are in addition to, that have requirements in addition to what is in the e-sign Act in 101C. Additional disclosures, calling for an actual signature within the consent itself. So be mindful and look at these requirements. The NAIC in April basically came forth from an activity that started in 2020 because of COVID, and agreed to form a small working group to make recommendations on how to proceed on a go-forward basis with some of the temporary measures that were put in place to enable insurance transactions during the COVID pandemic. The group is going to now survey insurers on best practices and attempt to provide uniform guidance on electronic signature and electronic notarization to really, push forward the adoption of electronic disclosures and/or policies and statements. The chair of this group is the Maryland insurance commissioner, Kathleen Brain. She was a former partner at DLA. She is wonderful and engaged, and I think it's going to be an exciting time. Insurance really has been a sector that has been in the lead with respect to insurance. NAIC came out early after e-sign was enacted and promoted the electronic commerce environment.
Next thing we have up is changes to various business corporation acts. Those of you who have had an opportunity from time to time to sit in a room filled with corporate attorneys and ask them about the extent to which a board of directors communicating with each other or shareholders can use electronic communications or remote electronic meetings probably enjoyed the physical fist fight that followed among those attorneys. You could start a real argument in a room full of corporate attorneys about just exactly how much could be done remotely and to what extent, in order for it to be remotely, it had to be part of bylaws, or it had to be part of the articles of incorporation, or it couldn't be done at all because of some prohibition in a statute or a particular wording in a statute in a particular state. So the good news is that we're seeing states move to try to clarify that situation. The bad news is that what they're choosing to clarify varies considerably, both in terms of exactly what the rules are and exactly what topics they've decided to add clarity on. For example, we have recent enactments in Colorado, Oklahoma, and Washington. They are all different, both in terms of what they cover and how they approach the subject. Generally, they are intended to enable electronic communications among directors, electronic communications with shareholders, the obtaining of electronic consent, and at least in the case of Colorado, electronic participation remotely in shareholders and directors meetings. But there isn't really a good way to kind of summarize or to generalize from what exactly these statutes authorize. You really have to go to the individual statute and be conscious of the individual state law that governs the behavior of your corporation to know exactly what's been authorized, and also to know to what extent it really needed to be authorized or simply could be done anyway, or could be addressed through bylaws or through the articles of incorporation. So this is an area where state law still varies terrifically, and what can be done and how it can be done is in no way uniform right now. Finally, we have a fascinating effort going on by the Uniform Law Commission. Article 12 is a nascent new article for the Uniform Commercial Code being worked on by a combination of the Uniform Law Commission and the American Law Institute. And it would extend the concept of control that currently applies to electronic equivalents of negotiable promissory notes and electronic chattel paper out to virtually any document that evidences a payment intangible, as that term is defined under UCC Article 9. Why is that particularly significant? Since today, an awful lot of payment intangibles don't have any kind of documentary documentary evidence at all. It's significant because of its potential application to non-negotiable promissory notes, which is, of course, is both for commercial and for consumer transactions, a far larger category of promissory note than a negotiable promissory note outside of first residential mortgages. So the Article 12 draft, as currently written and as it is proposed to go forward, and it is supposed to be completed by July of 2022, would actually apply control to non-negotiable promissory notes. And this would be a particular value because right now, most non-negotiable promissory notes under Article 9 are what are referred to as instruments under Article 9, meaning it is possible to take a super priority in them by taking possession. So now the concept of control, always intended to replace possession with respect to negotiable promissory notes and chattel paper, would also then apply to non-negotiable notes, greatly expanding the opportunity to have rapid liquidity for debt obligations in both commercial and consumer environments beyond where electronic records will allow you to do that today. Stay tuned, because this is probably going to get interesting in 2022, because the new article is complicated and does have a lot of nuances in it as it's currently drafted.
And it's intended to cover even broader types of digital assets, including non-fungible tokens and other aspects of digital assets in addition to non-negotiable instruments. And David, correct me if I'm wrong, but I believe that Nebraska has jumped the gun and already enacted Article 12 in its draft form. So
that is correct.
More to come on that.
Right. The Nebraska legislature was desperate to prove that Nebraska is open for digital business. So they went ahead and adopted it, promising the Uniform Law Commission that they would amend to adopt the final version when it comes out in July.
So at the federal level, there's, as I mentioned at the outset, we're not covering everything, but here is what we thought was interesting. The IRS continues to enable, driven by COVID, the use of electronic signatures on a whole slew of IRS forms that are filed with the government. Ginnie Mae has 2021 guaranteed a pool of mortgage-backed securities for the first time, with the entirety of the pool being e-notes. And the next two pages are Federal Reserve Bank links and Federal Home Loan Bank links with respect to accepting e-notes as collateral. You'll get a copy of this presentation, but I think what we found interesting was the hardest nuts to crack. IRS, Ginnie Mae has been a holdout for a while. The Federal Reserve Board and the Federal Home Loan Bank are really, moving forward. Now, the guidance is for the Federal Home Loan Banks is a little bit more uniform than the Federal Reserve Banks, but everyone has their toe in the water and understands that digital assets in the form of e-notes are here to stay, and they're looking forward to moving forward. So
I'm going to talk a little bit about ongoing issues and things that are still in flux. And we'll start with our old friend, electronic signatures in attribution, intent, and effective presentation. Just as a quick reminder, what's all the fuss about? Legal sufficiency versus attribution. One of my favorite explanations, UETA and e-sign answer the question, is it a signature, but not the question, is it your signature? And the burden of proof generally is on the person seeking to enforce the signature. And so courts are continuing to look at several different issues. There's a continued scrutiny with respect to proof of attribution, with respect to whether or not there's an intent to create a signature, and whether or not there's effective presentation. And yeah, there we go. Next slide. Yahoo! We're going to start with attribution. Fine distinctions in skeptical courts. One of the kind of the trends we're watching at the moment is that courts are starting to develop a more kind of particular skepticism about attribution of signature in situations where the signature is challenged by the purported signer. And they're kind of looking at three different sets of issues. They're looking at the employer's access to or use of employee credentials when an employee is supposedly the person who has signed something. They're looking at the sender's access to an alteration of documents either during or after the signing process. And they're looking at the adequacy of the audit trail for the signing transaction. Now, we're not going to try to go through all the cases that are here on the case illustration on this slide, but just to highlight a couple to give you kind of a flavor for the thing. If you were to look at Fisher versus Bird Rides Inc., for example, the issue that really turned up in the Fisher case was that there was no specific audit trail, despite the fact there really was supposedly a authentication process that the plaintiff in that case had to go through, and that the plaintiff therefore should be bound by an arbitration agreement that was executed, that there was no audit trail supporting this supposed secure authentication process for the particular signing event that occurred with the plaintiff. Instead, there was just kind of a general explanation of what that signing process would have been, but no proof that this particular person actually went through that process. The court in that case held that the absence of information about the particular signing experience that the particular individual had, the absence of that proof, kept the signature from being enforceable and from the contract being enforceable. In the Hazlitt case talks about employer control. In the Hazlitt case, the situation was that all through the signing process, supposedly the employee was entering the last 4 digits of her social security number over and over again as reviewing the documents. But it turned out that what was actually happening was that the employee was sitting with a manager in the offices of the company, and the manager never released control of the computer to the employee. The manager kept flipping from document to document, and the manager kept entering the 4 digits of the social security number. And the court said, well, that doesn't constitute anybody's signature on those documents. Finally, I'm going to mention just one more case out of that list, and that's the Aerotech case from the Texas Supreme Court. That case is worth taking a serious look at, actually reading through if you're a practitioner in this area, because in that case, the Texas Supreme Court held that the authentication and audit trail process that was used was sufficiently complete and sufficiently detailed that absent some kind of proof of impropriety offered up by the signer, it was not enough for the signer simply to say, no, I didn't either sign that. That did not create a question of fact, and that essentially the party wanting to enforce the signature was entitled to enforce as a matter of law without having to go to a trier of fact, because the audit trail and the authorization process was so good. The court talks about that process in excruciating detail in the case, and it's valuable. But there's another fun thing to note about this case. If you're a practitioner in the area, it took 3 courts to get there, because both the district court and the Texas Court of Appeals didn't agree. They both said that despite the clear authentication process, the clear and detailed audit trail that was produced, that it was enough for the signer to simply say, no, I didn't either, to send the entire question to a jury. And the decision at the Supreme Court level wasn't unanimous. There was a dissent by a judge who said, yes, that's right, it should be enough that the signer simply says, no, I didn't either. What does this mean? This means that we can look to see that this is an area that is still going to be unsettled, and that there is not necessarily, as of yet, still a complete judicial agreement across the United States as to what the appropriate levels of proof are. By all means, go and take a look at the Aerotech case. The next thing we're going to look at for just a moment is intent to sign. There are, again, a number of cases here. We're not going to go through all of them, but in general, what we are seeing is that the court is looking with respect to intent to the question of how clearly it is expressed in the documentation or the surrounding circumstances that the person who is supposed to have signed the document understood they were creating a signature and intended to do so. Couple interesting things to note is that we are still all over the map with respect to what has to be done for an email to constitute a signed writing. If you look at the Philadelphia Insurance Indemnity Company case, for example, which is decided under New York law, the court concluded that with respect to email, there was no real difference between thinking about a pre-populated or a retyped signature. In other words, if I send an email and my signature, David Whitaker, partner, DLA Piper, is pre-populated at the bottom of that email, that can still constitute my signature. Or it can be my signature if I type in my name at the bottom of the email as well. But the mere fact that it was pre-populated doesn't keep it from being my signature. The court said, well, it depends on what my intent was when I sent the email. And if I intended to be bound by the message in the email, then the pre-populated name can constitute a signature. You can see all the potential for mischief and confusion there. And finally, we'll talk just very briefly about Parish Transport, which is the one case in this list where intent was not established. And in that case, the court looked at an email chain again, where one email in the chain was actually signed with a typed name by the sender, but other emails that came later in the chain by the same sender were not signed with a typed name. The court said 2 things. One, the fact that you signed the email 4 emails back doesn't mean that the other emails that came later are signed, which seems a sensible conclusion. And also, yeah, don't talk to us about the name that's dumped into the thumb on the email. That's not a signature. That's just the return address. It's not a signature at all. So things to keep in mind when you look at whether or not you've established intent to sign. Some of these cases, like the Dandridge and Cruz case, provide good guidance on ways to help establish clearly in your process that the customer or your counterparty intended to sign the documents that are being presented.
And last but not least is distinctions, skeptical courts, and inquisitive regulators looking at effective presentation. Before we move to presentation, I did want to just comment on the attribution slides to say that there is a distinction, and we get this question all the time, where it's, between authentication or identification of the signer and then attributing the act taken to sign with the signer. There are two things that are going on there. So in terms of when you think about building your processes, you might have, a great, KBA or, other type of identification, verification process that the signer really is who they say they are. But then during the process, being able to insert a connection between the signer and the checking the box or clicking I agree and what have you. It's not the cat. Okay, so presentation. To David's, following on David's observations, the courts are in some ways skeptical and in other ways supportive. And in order to get to support, they're looking at the details. They're looking at the presentation of the information. They're looking at buttons. They're looking at wording. This isn't new, but it continues page by page through a process. A fact-intensive inquiry is being done by the courts. They're no longer is it the browse wrap, click wrap, all is well. Notwithstanding the fact that we are 20 plus years down the road. The courts are now paying, and we've been saying this for the past few years, more and more attention. They're looking at how the hyperlinks are labeled. They're looking at whether there was too much clutter on the page, whether the information that you're presenting was obscured by colors or words or clutter. Is the information terms of service, privacy policy, whatever it may be that's important, arbitration provisions, it is the essence of that nestled between extraneous text. Is it not highlighted? Is it not underlined if you're presenting by hyperlink? What does conspicuous mean in an electronic environment? We've mentioned this particular concept on a few other presentations. It's called net impression, meaning what was the customer, signer, viewer, consumer's impression? Did they have to click yes or check a box because of the way that the information was preceded? It was, you lead the horse to water and they then drink, and was that a meaningful, action taken? So really do think about your design process. We've also mentioned this case in prior presentations. This is 2015, Berkson versus Gogo. And this is exactly where the courts are going, and we'll talk in a minute where the CFPB may be going with their recent request for comment, looking at trends, looking at empirical evidence, behavioral trends, scientific, knowledge, demographics, and such as to who's doing what on the internet and what does it mean to be the average internet user. In this case, the court consulted what was available in 2014 and 2015 with respect to empirical and academic sociological studies. It did this to formulate an acceptable understanding of the knowledge of what is the customer really paying attention to when they're looking at a web screen. They studied demographics, they studied eye tracking tendencies. We put this screen up here because we thought it was just so fascinating where they were tracking with this heat map in colors where internet users looked. Red was, the most looked at, yellow was second, blue was third, and the gray areas weren't looked at all. How customers process information was also studied. Reading comprehension on a screen versus on paper. There were studies that were cited in this case that is over 100 pages about the use of hyperlinks, the amount of data that's insufficient to help assess actually whether customers have read the information. Just because, for example, just because they click doesn't mean they've read. Just because they forward or share doesn't mean they've read. So all of this is, I think, extremely interesting. And where we're going with this is that the CFPB published, and is still open for comment, closing this week, on mobile device presentation. And they're going to start looking at psychological measurements of comprehension and study how consumers are actually engaging. So this is something that everyone should be mindful of, and perhaps it could be a good public policy effort for Ezra to participate in a CFPB effort to do some, anecdotal or other type of studies of members, customers, and share that information with the CFPB on the consumer benefits of using mobile devices and the presentation of information.
Right. And on that topic of, studies of the ways in which we are interacting with our technology, or our technology is interacting with us, the topic of artificial intelligence has been at the forefront of a lot of regulators' minds this year, as evidenced by the items you see on this particular screen. The Federal Reserve Board, one of the governors, Lael Brainerd, in early January, gave a speech in which he focused on the potential use of artificial intelligence and its emerging use in the financial services market. This was followed by 5 federal agencies, including the FRB and CFPB, OCC, publishing a request for information on the use of AI by financial institutions. The House Financial Services Committee reauthorized its task force on AI. And basically the message of all of these different communications and different efforts is Skynet is coming, okay? The concern is, and I think, and I don't mean to make light of it, it's a legitimate concern, is that artificial intelligence can produce results that the artificial intelligence thinks are predictable, but that other folks might not think are predictable, or that may include consideration of data elements or data trends that are potentially problematic in terms of their impact on particular customer groups. And so a lot of the concern you see from the FRB and from the 5 federal agencies and from the House Financial Services Committee have to do with transparency. And the concern about what Governor Brainerd called the black box. Data goes into the artificial intelligence black box, and then a decision comes out, but it's not necessarily clear what went on in the black box to affect the decision. So there is a particular desire to see how it is going to be possible to preserve transparency with respect to decision-making processes. And you see essentially that set forth in the FTC's post on fair and equitable use of artificial intelligence. They set out a number of key points. In particular, you are supposed to be watching carefully for disparate impact. according to the FTC, to embrace transparency, to not exaggerate what the algorithm can do, be truthful about how you're using data. And the one I found most fascinating, the last one, which is do more good than harm. That was kind of interesting to me because I would have thought it would be do no harm, but it's do more good than harm, which is more of a balancing kind of attitude than you usually find from federal consumer protection agencies, particularly under a Democratic administration. So I thought there was an interesting sort of tacit recognition that exactly what's a good and what's a harm can kind of depend on the beholder to a certain extent, and that any kind of technological advancement like this may not be a completely clean implementation, at least immediately or initially. And that there may be some development and some experiential learning involved in order to get the balance of the considerations in place for artificial intelligence exactly right. But I think we can expect it to continue to grow as a tool that's being used, particularly in financial services. But I think you can also expect there to be continued close scrutiny and questions about exactly how it's being used and how decisions are being made.
Okay, remote online notarization, 37 state statutes. This has been an incredible effort over the last 2 years by states to enable remote online notarization, obviously accelerated by COVID. There are notable differences, notwithstanding the effort toward uniformity. We're not going to be able to talk about all of them, but some of the highlights are special notary registration requirements or RON platform approval. Not every state requires approval. Some do, some don't. Some require uploading various types of information to a portal. Some don't. All do have an authentication process for the signer. What's acceptable proof of identity or required elements to the identity tests, or how to treat drop signers and whether they need to re-authenticate vary from state to state. Some address it, some don't address it. Some may address it, but it's not clear with the way that the laws or regulations are written. Location of notary and signer. Some statutes place limits on the signer's location. All states require the notary to be in the state where the notarization is taking place. The continuity of the audio visual recording. Some statutes require the AV recording to be continuous and uninterrupted. Again, what does that mean with respect to drop signers? And what does a dropped signer mean? Does that mean that someone walks out of the view? Does that mean that if you have multiple signers, do they all need to be seen? Does that mean that there's bad internet connection and you drop for 1 minute, 5 minutes, 10 minutes, and there are different processes and procedures that you would want to implement based on whether the state has expressly addressed that or not. Documents eligible for remote notarization. At the beginning, David mentioned will legislation, e-will legislation. That would be an example of, yes, you can remotely do a RON in a particular state, but you might not be able to do a will, even if there is an e-will. So there's you should absolutely look at the laws to make sure that it covers the types of documents that you're intending to notarize. Record keeping requirements for the notary, information that the notary must retain differs. How long you must keep the information differs. Access to the electronic journal by others is either addressed or not addressed, or if it is addressed, differs from state to state. So the good news is that there's a lot of progress in this area. The not so good news is that it really is a state-by-state analysis. There has been, excuse me, a lot of emphasis and a lot of questions on interstate recognition, and there's support for interstate recognition, meaning that you conduct a notarization in one state and it, so long as you do it in compliance with the state law, that it should be accepted in another state. Statutes, interstate recognition statutes exist. Again, you want to look at them to be very clear, their breadth and scope. There's the full faith and credit clause of the Constitution, but there is always the public policy exception. So in this area, it hasn't been overly litigated yet. So, the question is going to be, will the courts apply these principles of interstate recognition and full faith and credit as they've done over the last, 100 years, or is remote online notarization going to be, a different animal, or will states end up, if there is too much interstate recognition, enacting laws, as did Iowa initially, but no longer, to expressly not enable interstate recognition. We are going to talk about one case. I'm going to hand it back to David to do that. This is our only judicial support yet for Ron, but we're excited that it exists.
That's right, because it's actually very positive, and Margot alluded to the fact that we're not quite sure how the courts are going to deal with the application of full faith and credit, which has been applied quite broadly to notarization generally, how it will be applied to remote notarization. But there's another principle that has been part of notary law for a long time, and that is that minor technical defects in a notarization are not going to be looked at as impairing the effectiveness of the notarized document. The feeling has always been by the courts that that is essentially penalizing the good faith participants in a notarization process for something that they usually have no knowledge of or control over, which is technical notary requirements. And what happened in Ryerson was that under the state of New York's temporary COVID-19 authorization for remote notarization, the notary and the person signing a marital separation agreement all gathered together in a Zoom call like this one, and they went through the process of signing the document, which also has to be notarized. But under the rule, what was supposed to happen was, after everybody watched everybody else sign, the original document, which was actually a paper document, was supposed to be packaged up and mailed the same day to the notary. So the notary then could execute the acknowledgement on the paper document. Well, it didn't get sent that same day. It got sent a couple days later, and it was 4 days later when the notary finally got it and actually executed the acknowledgement, which wasn't really in technical compliance with the requirements under the temporary rule. The court found that there wasn't any specific time limitation on the execution of the certificate of acknowledgement, even though there was a time requirement for getting the darn thing in the mail to the notary. And the court said, look, we're not going to worry about that minor technical defalcation here. Nobody is arguing that the people involved didn't actually all gather on the Zoom call, didn't actually all say they wanted to sign the document, didn't actually sign it, and that it didn't eventually get stuffed in the envelope and sent to the notary, nor is anybody arguing that the notary didn't actually execute it. They're just arguing that it wasn't stuffed in the envelope fast enough. You know what? We don't care, okay? We're not going to invalidate the notarization over such a minor defect in the process. So we do get our initial indication from the Ryerson case that at least one of the principles that's applied to notarial acts from time immemorial, which is, minor technical defects don't count, will continue, we hope, to be the rule in an electronic environment.
And interestingly, some of the state RON laws have addressed technical non-compliance and have said that the notarization will be valid. However, technical non-compliance can be used in a court of law to prove fraud or unconscionability or other concepts. So technical compliance per se won't invalidate a notarization. However, it can be used as evidence. What we've found, and consistent with this case, is that things that are technical non-compliance issues that aren't related to authentication or duress or other really core concepts aren't going to undermine the courts upholding the notarization. Okay, just in the interest of time, we did want to mention state biometric privacy laws. There are a few states that have them. It dovetails with the remote online notarization concepts as well because of the audio video. But in addition to that, even if you're not doing a RON, but you're doing a interactive, voice response unit, or you're, using thumbprints to enter your office building or what have you, beware of looking at the definitions in the states that do have laws as to what is a biometric identifier to make sure that you're not running afoul of these laws. Essentially, the requirements are to get consent and maintain the information in a secure way and to dispose of the information in a secure way. But super important when you are back to the RON context, to get, express consent and document that consent as part of the process. David, I don't know if you want to just talk really quickly about the just mention it.
15 seconds.
And yeah.
On Rosenbach, the bottom line in Rosenbach, in the state of Illinois, if you take somebody's biometric measurement that's covered by their statute, in this case, it was a thumbprint at Six Flags, and you don't go through the disclosure and consent process, it doesn't matter that I didn't suffer an actual injury. I still get $1,000. Thank you so much, plus my attorney's fees. According to Illinois Supreme Court, who said, to no one's real surprise, statutory damages mean statutory damages. No actual injury is required. The injury is the failure to follow the consent and disclosure process in the statute, and that's enough.
Which is different than some of the other privacy litigation where injury has been required. Okay, so we have a bunch of resources. You can read them. They all, some are more recent than others, but they all have stood the test of time, and
yes,
share them with you. So Steve, I'm going to turn it back to you.
Thank you, Margot. One of the things that has been universal over the decades is that when Margot and David present content, they have more content than time. So thank you very, very, very much for sharing it with us. Very quickly, because we literally are now out of time. This is just to highlight the fact that a lot of the things that Margot and David addressed today are public policy initiatives of ESRA. The notary, the Federal Reserve, these are all active committees and groups that we're in our public policy group, and we would hope that you would join and participate with ESRA to assist us in these initiatives.